An appeal has been filed in the Delphi case. Here's what that actually means and where the case stands right now. Because an appeal is not a new trial, it is not new evidence, and it is not fast.
It is not a process where witnesses are called back or where new facts are introduced. It is a review of what already happened. That's it.
What an appeal actually is a structured legal review of the case, not based on opinion, not based on headlines, but based only on the record. And when we say the record, we mean something very specific. The record is the transcripts, the filings, the motions, the rulings, and the admitted exhibits. Everything preserved in the official court file.
And that matters. At the appellate level, the court does not go looking for new information. It does not investigate. It does not reconstruct the case. It reviews what is already there.
So if something is not in the record, it does not exist on appeal. This is part 3 of our Delphi series. This episode does not revisit the timeline. It does not re-argue the trial. It documents what happens after the verdict, based on the appellate record as it stands.
And the structure here is the same as every episode. We are working from documented filings. When we reference a motion, an order, a brief, we are referencing what was filed in the court.
We will state what the record shows. We will explain what that means procedurally and what that means for the case. Not speculation, not theory, the record. The appellate phase begins with the outcome of the trial. According to the sentencing order entered December 20th of 2024, Richard Allen was convicted of 2 counts of murder and sentenced to 65 years on each count to be served consecutively for a total of 130 years.
That is the judgment. That is what is being appealed. Nothing else.
Following sentencing, the defense filed a motion to correct error. This is governed under Indiana Trial Rule 59, which allows a party to request review of alleged legal errors before the case moves to appeal.
According to the appellate record, that motion was denied on February 14th, 2025.
And that matters because Indiana procedure, a motion to correct error must be resolved before the case moves to appeal. On March 11th of 2025, a notice of appeal was filed, initiating review in the Indiana Court of Appeals.
And according to that filing, the defense requested transcripts, records, and proceedings spanning from pretrial hearings in 2022 through trial in October and November 2024 through sentencing.
Which tells you something critical. This is not a narrow appeal. It's not one issue. It's not just one ruling.
This is a request for the appellate court to review the case as a whole, all of it.
Pretrial decisions, evidentiary rulings, trial conduct, all of it, as preserved in the record. This is the moment where the case stops being about evidence and becomes about whether the process was legally sound. Before the appeal formally begins, the record already shows the scale of this case is an issue.
On December 19th, 2024, trial counsel filed a motion requesting referral to the Indiana State Public Defender for appointment of appellate counsel.
Specifically, authorization for 2 appellate attorneys.
That request is not automatic. It reflects the size and complexity of the case.
According to subsequent filings, the court approved that request, and appellate counsel Mark Lehman and Stacy Oleana were appointed, with the court formally concurring in that appointment. What that means is that before the appeal is even filed, the case is already being treated as too large for a single issue review.
Multiple attorneys are required to review the record. That's not typical.
Because the record is not small. It includes years of pretrial hearings, multiple motions and rulings, a multi-week jury trial, and sentencing proceedings.
And all of that has to be reviewed and cited before a single argument is made.
This is not a quick process because this is not a small case. Once the notice of appeal is filed, the case does not immediately move to arguments. It moves to the record.
Because before an appellate court can review the case, it has to have the complete record of what happened in the trial court.
And that record is not automatic. It has to be built. According to the appellate docket, on March 13th of 2025, a notice of completion of the clerk's record was filed. But at that same point, the transcript was not complete.
And that matters because the transcript is the official record of what was said in court. That means the written filings, motions, orders, and documents have been compiled. But the transcript, the record of what was said in court, was not complete. That matters.
Without that, the appellate court cannot fully evaluate what happened. An appeal does not run on memory, it runs on transcripts. According to a motion filed April 17th of 2025, the court reporter requested additional time to complete the transcript.
On April 22nd, 2025, the Court of Appeals granted that request, extending the deadline to June 9th, 2025.
Then again, on June 3rd of 2025, a second request for additional time was filed.
And on June 6th, 2025, the court extended the deadline again to July 9th, 2025.
What that shows is that even at this stage, the size of the record is already affecting the pace of the appeal.
This is not unusual in large cases, but it is significant.
Because until the transcript is complete, the appellate attorneys do not yet have the full record to review. According to the docket, the transcript was filed July 2nd of 2025, with the notice of completion entered July 7th of 2025.
At that point, for the first time, the full record was assembled. Now the case can actually be reviewed.
That is when the real appellate work begins. But even after the record is assembled, the filings show it is not complete. According to a verified motion filed September 17th of 2025, appellate counsel for the defense requested that the court compel the transmission of exhibits that had not been included in the record.
That means materials from the trial proceedings were not yet part of the appellate record.
And this is where the appellate process becomes very real, because at the appellate level, the court does not go back and gather evidence.
It reviews what is in the record.
So if something is missing, it is not considered. If it is not in the record, it does not exist on appeal. And according to the docket, on November 10th, 2025, a notice of filing of supplemental exhibit volumes was entered.
Which means additional material had to be submitted after the record was already considered complete.
That is not part of the initial build. That is a correction.
So what you're seeing is a process where the record is still being finalized after the appeal has already begun moving forward.
And that matters because everything that follows depends on that record.
The arguments, the responses, the review, everything depends on that record. All of it.
An incomplete record means an incomplete review. At this stage, the case is no longer shaped just by what happened at trial.
It is shaped by the size of the record and the time it takes to process it.
Because once the transcript is complete and the record is assembled, the next step is briefing.
That is where the attorneys take the record and build their arguments.
But even here, the filings show that time continues to expand.
According to the docket, Appellate counsel for the defense filed a verified motion for extension of time to submit the appellate's brief,
which reflects that even with the full record in hand, the volume requires additional time to analyze and present. That is what it looks like when a case is too large to move quickly.
That is not unnecessary delay.
That is scale. Once that process is complete, the appeal moves into its central phase,
the arguments.
Because this is the point where the defense takes the full record and identifies what they claim went wrong. At the appellate stage, the defense is not retrying the case.
They are identifying what they argue are legal errors based on the record.
And those arguments are presented in the appellant's brief. Once the record is assembled and reviewed, the defense files the appellant's brief.
This is the document where the defense lays out its claims of error.
At this stage, the defense is not presenting new evidence. They are not calling witnesses. They are not retrying the case. They are identifying what they argue are legal errors based on the record. And those arguments are structured around specific points in the case where the defense claims the process did not function properly. These are claims, not findings. According to the appellant's brief, one category of claims focuses on evidentiary rulings.
What that means is the defense is arguing that certain evidence was admitted at trial in a way that did not comply with the rules of evidence.
That can include how physical evidence was presented, how expert testimony was handled, and whether certain conclusions were allowed without sufficient foundation.
So this is not just about what the evidence was.
It's about whether the jury should have been allowed to hear it in the way that they did. A second category focuses on pretrial decisions.
What that means is the defense is challenging rulings made before the trial began that shaped how the case was presented.
This can include what evidence was allowed, what arguments could be made, and how the defense was permitted to respond to the state's case.
Because once those decisions are made, they define what the jury will ultimately see and what they will not.
Another category focuses on limitations placed on the defense during the trial.
What that means is the defense is arguing that there were restrictions on how they could challenge evidence, present arguments, or introduce their own case.
And that matters because a trial is not just about what the state presents.
It's also about whether the defense has a meaningful opportunity to test it.
And finally, the appellant's brief does not treat these issues as isolated.
It presents them as cumulative.
Meaning, the defense is not arguing that one issue changed the outcome.
They are arguing that when these issues are viewed together, they affected the overall fairness of the trial.
So when you step back, what the appellant's brief presents is not a single claim. It is a structured argument that errors occurred at multiple stages of the case. Pretrial decisions, trial conduct, evidence, and limitations.
All tied to the question of whether the process was legally sound.
At this stage, none of those claims have been decided.
They have been raised, they have not been decided.
Once the appellant's brief is filed, the process does not end.
The state files its response.
This is the document where the state addresses each of the claims raised by the defense and argues that the conviction should stand. This is not a new case.
This is a response to the same record and the same issues.
In response to the defense's claims regarding evidentiary rulings, the state argues that the trial court acted within the law when it admitted that evidence.
What that means is the state's position is that the rules of evidence were properly applied, and that the jury was allowed to hear that information appropriately.
In response to challenges to pretrial decisions, the state argues that those rulings were within the court's discretion.
Meaning the trial court had the legal authority to make those decisions and did not exceed it.
Regarding claims that the defense was limited in presenting its case, the state argues that any restrictions were appropriate under the rules of trial procedure,
and that the defense was still provided a fair opportunity to present its arguments.
Taken together, the state's position is that even when all issues are considered,
none of them rise to the level that would require reversal of the conviction.
So what exists at this stage is not a new narrative. It is not new evidence.
It is two sides interpreting the same record in different ways. Two competing arguments about whether the process was proper.
And at this point, the appellate court has not ruled on either. As of the most recent filings, the appeal is still in the briefing phase.
Following the state's response, the defense has one final opportunity to file a reply brief.
According to an order entered April 6th of 2026, the court granted a motion allowing an oversized reply brief with a deadline of April 23rd, 2026.
That means the defense is responding to the state's arguments within the issues already raised. Nothing new is being introduced.
So where does the case stand right now?
Not decided.
No ruling has been issued. What exists is a fully developed legal challenge to the conviction and a full response defending it.
And both are now in front of the Court of Appeals.
From this point, the process shifts from briefing to review. The appellate judges review the briefs, the record, and the issues raised. They may schedule an oral argument, or they may decide based on the written record. That process takes time.
Because the court is not deciding quickly, it is deciding based on the record.
You will hear that an appeal has been filed.
And assume the case is moving toward a decision.
What the record shows is something different.
The case is now being examined for legal error.
Across pretrial decisions, evidentiary rulings, trial conduct, and procedural limitations.
And that examination is not complete.
It is ongoing. And according to the record, that is where the case stands. Before we close this episode, we pause. Because cases don't just exist in courtrooms, they exist in real time. And while we've spent this episode examining a case through records, filings, and process, there are families right now waiting for answers.
This week's missing person spotlight is Jacob Curry. Jacob is 14 years old and is listed by the National Center for Missing and Exploited Children as missing from Indianapolis, Indiana since April 1st, 2026.
His case is identified as NCMEC case number 2082887 and NCIC number M278879834. At the time of this recording, there has been no official update indicating that he has been located.
If you have any information regarding Jacob Curry's whereabouts, contact the Indianapolis Metropolitan Police Department or the National Center for Missing and Exploited Children at 1-800-THE-LOST.
A missing person remains missing until they are found, and visibility matters. Sometimes, cases move forward because someone notices something small and says something.
And sometimes, that's the difference. If you value the work we do here, the records, the research, and the time it takes to walk these cases, you can support the Casewalker Chronicles through Patreon.
All of our work is built from documented sources. We cite those sources throughout each episode, and full source listings are available on our website. This work doesn't stop here. It moves into real conversations, real spaces, and continued engagement with others working in this field.
Every connection gives this work somewhere to go.
And we're grateful to have you here with us. This has been the Casewalker Chronicles.
and we hope you keep walking with us.